Hello everyone, this is Ritika Ghosh, and today I'm going to present my topic Companies Amendment Act 2020. So I'm going to be talking about what is Companies Amendment Act. Uh, this amendment has been passed in 2020 last year to the existing Companies Act, which was passed in 2013. So I'm going to share what exactly caused the Companies Amendment Act to come in 2020 and what are my views about it. To start with the introduction, we are altogether acquainted with the scandalous investors' debate of Bakshi, McDonald's, Tata, and Mistry. While such episodes of debates are normal, it is fundamental for us to comprehend that what might prompt such questions. So, in support of the view of public power to accelerate important and effortless living and cooperation for those associations that keep up the law, the Company Law Committee (CLC) in September 2019 examined decriminalization of various offences under the Companies Act 2013 with respect to gravity of each offence. मतलब पब्लिक इन जनरल को कंसिडर करते हुए पब्लिक में कॉपरेशन एफर्टलेस लिविंग एंड कंपनीज एंड पब्लिक के रिलेशन स्मूथ हो, इसलिए कंपनीज लॉ कमिटी ने Companies Amendment Act Laya for the gravity of each offence. Considering the suggestions of Company Law Committee, the public authority has looked to revise different arrangements through the Companies Amendment Act. This entire presentation is about the key changes which are accommodated in the Act and its extensive results. Further, it investigates whether the act is a positive development or not. So I'm going to be sharing few points जिससे हमें पता चलेगा if this act is a positive development to the Companies Act 2013. Now there are two compartments of Companies Amendment Bill. Number one is decriminalization of various offences in case of defaults, and the other is increasing of ease of living, of ease of doing business. So the main two factors of passing this bill was these two. That number one, decriminalizing various offences would reduce the burden and eliminate it from the reformatory customs. And second, this would promote, अगर हमने first point cover कर दिया, the second point would automatically get promoted, which is the increase of ease of living and ease of doing business. I will tell you further about it that the general pendency of cases in court. हमें ऑलरेडी पता है कि कोर्ट्स पे कितने वेट है फॉर द पेंडेंसी ऑफ केसेस. सो दिस एक्ट ट्राइज टू अपहोल्ड एंड गाइड विद अ गाइडलाइन बेस्ड methodology to decrease the pendency of cases in court. Further, the common and the financial disciplines, whether with or without changes, as in Section 86, Section 90, and so on, totally excludes offences from the tribunal's requests. Related gathering transactions have been decriminalized and the financial fine and punishment have been expanded, remembering the gravity and nature of these offences. इसका मतलब ये है कि जो ऑफेंसेस को कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी में आइडेंटिफाई किया जाता था, अब उन्हें डिक्रिमिनलाइज किया जाता है एंड पनिशमेंट तभी ही उन पे एक्सपैंड होगी जब उनकी ग्रेविटी एंड नेचर को आईएएम एंड ट्रिब्यूनल्स रिस्पॉन्ड करेंगे. Moving on, I want to share this little video of our Honorable Prime Minister Narendra Modi talking about the bill.
सरकार ने कंपनी एक्ट में बड़ा बदलाव करते हुए कई प्रावधानों को डीक्रिमिनलाइज कर दिया. साथियों, आज भारत दुनिया के उन प्रमुख देशों में जहां कॉर्पोरेट टैक्स सबसे कम है. ईज ऑफ डूइंग बिजनेस की रैंकिंग में सिर्फ 5 साल में रिकॉर्ड 79 रैंक का सुधार करने वाला देश भी भारत सरकार के इन प्रयासों के बीच विदेशी निवेशकों का भी भारतीय अर्थव्यवस्था में भरोसा लगातार बढ़ रहा है। In this particular set of amendments, the priority is to decriminalize this. So majority of what is being changed is to remove those particular sections or particular, what can I say, technical requirements, all of which result in giving the criminality to be offense which may not be at all intended to be mass of offense. So what we have done is statistical changes, all of which have been approved by the cabinet, which will result in amending 65 sections. The major thrust, of course, is looking at ease of doing business and decriminalizing.
So, as we heard, our Finance Minister Nirmala ma'am and Honorable Prime Minister Narendra Modi about it. Now, I will talk about the in-house education mechanism. So, it is the one of the key corrections which is acquainted by CAA 2019. So, the IM framework subbed the cycle of allure and settling under the steady gaze of National Company Law Tribunal (NCLT) with an online stage controlled by MCA corresponding to certain recognized offenses. The whole cycle is led through an online gateway and requires actual participation just in outstanding conditions. So the IM framework is accessible for offenses which draw in punishment of up to INR 2.5 million, and these can be reported to NCLT. These offenses incorporate, that is in Tombalia, giving offers of discount and specialized non-compliances identifying structure filings. Now, talking about more about the Companies Amendment Bill 2020, I'm going to briefly tell you about how the council was headed by Mr. Injeti Srinivas, who is the secretary of MCA, under the CLC committee report distributed on November 9, 2019. So, in decriminalizing the act, the law committee wrote command which was restricted to compoundable offences and was avoiding the offences for the public interest and non-compoundable offences. CAP 2020 spotlights on recommending an altered structure in regard of punishments connected to such compoundable offences under the Act. CAB 2020 बहुत जरूरी है, like a test of objective determination versus a subjective assessment. It does not merit prolonged adjudication, and therefore such offences do not need a long procedure of law, which could have been forbidden by promoting it to IAM. The Law Committee report noted that in case of civil wrongs, the wrongful action is bereft of any intention to harm. That means अगर कोई भी offense कोई technical requirement या procedure के proper ना होने से होती है, उसमें there is no intention to harm, no mens rea present, there is no wrongful intent or wrongful action predominantly in the offense, and thus this offenses can be well adjudicated in the companies itself. No need to elongate the procedure and the payment of prescribed penalty. The proposed by CAB 2020 to the Act in regard to decriminalizable offences can be put into three classifications. One is deletion of charging provision imposing criminal penalty. So hence the criminal offences that were to be regarded as a criminal penalty were deleted. Secondly, removal of punishment of imprisonment prescribed for an offence and its recategorization as a civil wrong. तो पहले जिस offences के लिए punishment imprisonment दी जाती थी by the NCLT, now they are decriminalized and they are now to be categorized as a civil wrong. That means a punishment that means an offence which is done by a normal person only with a fine that can be adjudicated well within the jurisdiction of IAM, well within the capacity of the company. These are the highlights that I mentioned. That first of all, what is a listed company? That a proposal has been placed to exclude listed companies and with the intention of getting listed, such as class of securities, from the category of listed companies. यहाँ पे ये amendment में section 16 is very important. I would say it is of utmost importance because इसमें it highlights rectification of name. I will explain it to you that if a company was registered with a trademark of a proprietor and the name is too identical or resembles with some other name, then the name should be changed within 3 months of the issue of CG. Further, with the view to decriminalize the offence, if committed by a company in case of default in this section, CG shall allot a new name as per the directions of ROC. सो पहले पेटेंट या कॉपीराइट के कुछ भी इश्यूज होते थे कि अगर गलती से थोड़ा सा भी नाम तुम्हारा सेम है या देयर इज सम स्पेलिंग दैट coincides with some other company's name, then the ROC shall issue a new, allot you with a new name and shall issue with a certificate of incorporation rather than criminalizing with a penalty. These are the other sections that are highlighted in the Companies Act. That is Section 129A, Section 135 CSR, which I completed in my last thing. Concluding the act, I would like to say that without a doubt, koi shak nahi hai that CAB has been fully beneficial for ease of ethical business, for simplicity of working together, and giving a smooth compliance to the companies as well as public. But according to me, what's more important than just decriminalization of offences under the Act is probably going to yield immaterial advantages. I think to explain my point, that as the law committee report noticed that criminal authorizations are more horrifying and lasting in nature, the expense of common punishments perhaps is a feature of maintaining a business in conventional course. In any case, the officials should not dismiss the way that decriminalization of special offences under the Act could transform it into an innocuous figure, which may neglect the look of satisfactory and fundamental consistency. So ऐसा नहीं होना चाहिए कि just because कुछ offences under the Act are getting decriminalized, तो हम neglect कर दे कि जो fundamental organization की जो fundamental consistency है, वो हम उन्हें significance ना दे. Another worry that I think is that the decriminalization which is proposed by this act will have the impact of empowering a corporate culture of cleansing defaults by simply reserving it to the administrative goal. इसका मतलब यह है कि मुझे ऐसा लगता है कि just by decriminalizing the few offences, वो corporate culture को बढ़ावा देगा, like empowering a corporate culture over judiciary. Because the offences are getting resolved in the IAM, which is in the company itself, तो एक corporate culture का position and the administrative goal will be more than the judiciary, and that would kind of harm the functioning of the nation as a whole. Simultaneously, decriminalizing of offences and defense of their own financial obligation is like a self-satisfied view and less watchful methodology. The brief time frame of CAA 2019 and presentation of CAB 2020 appears to be impactful to the administrative changes of corporate laws. While it would require some investment of the organizations to receive the rewards of the revisions proposed by the punishments under CAB 2020, the equilibrium which is basic to accomplish the generic goals should not be lost. The basic primary factor जिससे ये act बना है वो खो ना जाए. That is the most important. If all of these factors are kept into mind and they are taken into consideration, I'm pretty sure that this bill would be one of the most golden amendments of the entire nation. Thank you so much.